Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London, and this morning I'm looking at a book which I found fascinating. It's a subject close to my heart because I find the area of law particularly interesting to teach, and also in terms of practice. The book is from Wildy, Simmonds and Hill Publishing, extremely helpful for practitioners. It's called Covenants and Freehold Land. It's been written by Christopher Jessel. Now, Elizabeth was the lead writer in this book, and it's a first-class book. Like all Wildy's publications, they are extremely helpful for us as practitioners, both at the bar and for solicitors. The title of our review is An Englishman's Home is His Castle, Expert and Authoritative Guidance on Positive Covenants. And we all know what a covenant is. It's a promise, and it's something many people who are students will like to run well away from. But it actually, in terms of the human element and the interest, it's a great subject to teach. Let's look at the book first of all. If you say I'm an enthusiast. There's the front, there's a spine, there's nothing on the back there. It's a hardback, like dark green, Lincoln green I suppose, colour, or a bit darker than Lincoln green, I don't know. The index at the back is by page numbering. It's got quite a good index actually. I was quite impressed with. References are to page numbers, there we go. It's got a lot in it because if you're looking for things, the index is probably your first port of call. If we go to the front, there's the front page there. And then after that you've got the blurb about Wildy's, then you've got the contents section, the usual stuff is there. It starts with the problem, freehold covenants, restrictions on the register, and running all the way through from there. And you see you've got a whole range of different titles, different chapter headings rather, ending up with the final chapter towards the solution, because remember it is positive covenants and freehold land, and it's really looking at the fact that there are some problems in this area and trying to come up with solutions. So it's towards the solution. Then you've got the precedents which are at the back, which will be again of help I think to practitioners. There we go. And then we get into a preface. There's a little bit of footnoting as you can see at the bottom. The preface is dated the 3rd of April 2019 by Mr. Jessel, and he sets out what his purpose is. Then you've got the short table of cases. The usual suspects are there. I always have a little look to see if certain cases are there, and they are. So there we go. Then you've got the table of statutes. I'm not going to mention which favourite ones I have in cases either. Then you've got, after the statutes, you've got the statutory instruments, of course, as well. Then a table of land registry publications, quite useful. One of the things I've always been quite interested by is the fact that people don't understand how the land registry works, and I think this book will help them a little bit. Table of international conventions, table of abbreviations, not very many here, you've got a few. And then we go to the problem. The preliminary comments, you've got paragraph numbering, and the book is about the way in which positive obligations combine land in successive ownership. There is a well-established rule that a positive covenant binding freehold land cannot be enforced against a successor in title to the original covenantor. Despite that, conveyancers have devised various methods to validate such a covenant. In addition, statutory powers can bind the landowner for the time being, and the law of tort can impose duties for the protection of neighbours and visitors. So there we go. That's the basis of the problem in land law. This book may be of interest, of course, to students as well. Going into the middle of the book, you can see how it goes. And as I said, the problem, as I have always seen it, and I notice it in court in the property cases I have, is that the difficulty is the lack of understanding about what the land registry do, what their powers are, and quite often when you get to a court, the judiciary also don't really know what powers they've got. And that's why you need a specialist member of the judiciary. I can think of some judges I've been in front of who know exactly where we go with this type of work, and that does help, because you've got to remember here, we've got statutes, but go back to your history of law. The concept of the common law was not to bind the land forever. And that's, of course, one of the basic, if you go into jurisprudence, that's the basic concept that we're talking about with this book. And as I say, I think it's a first-class work. So if you're a lawyer dealing with freehold property and related matters, this is the book for you. Such are the intricacies, technicalities, subtleties and complexities of positive covenants and freehold land, that the publication of this book, we think, will certainly be welcomed by practitioners in search of an authoritative and a very handy legal text on the subject. And of course you could quote from the book, possibly if necessary in a case, although it depends very much on what the case is about. And of course it's published, as I say, by Wildy, Simmonds and Hill, who give us a great service. Now the author is Christopher Jessel, and he's careful to define key legal terms at the beginning of the text, as they are fundamental, he says, to the understanding of the subject in its entirety, starting with positive covenants. And a covenant, of course, as I said, is a promise. In this context, quote, a solemn legal promise, usually in the form of a deed, says Jessel, although it can be created in other ways. And as I've indicated right at the beginning, you start on the basis that you shouldn't be tying up the land indefinitely. But of course, lawyers, we work around these to satisfy the requirements of the clients. So the balance has to come in. As I said, it starts off with the problem, then it looks at the solution at the end. Now, as a positive obligation then, this covenant is a commitment to do something, so a positive covenant requires action, except that it binds only the person who has given it. Conversely, a restrictive covenant, you remember all about them, like a restrictive obligation, effectively prohibits action in that it can bind land, sometimes the common law, something of sort, as I say, which the common law was never too keen on. This is the binding of the land itself. And of course, you have to look, I mean, the classic example, I'm going off the basics here, but the classic example is what would have been appropriate 2 centuries ago may not be appropriate today. So you can see the differences and the changes that must take place over the centuries. Now, in addition to that, other key terms are defined specifically in the text because they do have both specific and precise meanings. They include neighbour covenants, fences, etc., facilities, service charges and more. And of course you will find books on things like service charges, a very separate subject matter in its own right. And covenants referred to in this text, says Jessel, quote, principally affect people living or working near one another, whether as neighbours or sharing common facilities on an estate, whether the covenant is for the physical work or for the payment of money, it has to benefit land. And that, of course, is the key point. And just remember that I'm sure many practitioners don't need to be reminded of the very large number of neighbour disputes that we have regularly in the courts. It's not going to go away, and it's very, very large percentage of people who are involved in disputes with their immediate neighbours. Interestingly, the time-honoured observation that an Englishman's home is his castle was made in a case in 1604 concerning a lease. And Jessel observes here that by the 17th century, English law had come to protect rights to property as almost a supreme value. He adds that in his view the English Civil War was at least partly fought out of the concerns that property rights were at risk of being overridden by King Charles I. Well, there's that and quite a lot more, but I think that's an important point that he makes, and let's hope that a future government won't regard property rights in a similar vein. We can hope. Essentially, the book deals with the long-established rule that, as the author puts it, a positive covenant binding freehold land cannot be enforced against a successor entitled to the original covenantor, the very basis of the problem. There is much discussion on this point, including references to various devices to outflank the rule, and that's really what, in fact, is going on. Let me finally draw this to a conclusion by saying readers requiring additional insights and information will be pleased to note the extensive table of cases. As I said, all the usual ones, all the usual people are there. Statutes, statutory instruments, the land registry itself, publications from them, and the international conventions. And you've also got more than 30 pages of precedents right at the back of the book. And for property lawyers, property owners and developers alike, I think this book would be a useful addition or acquisition for you. And I think people who in this day and age are unrepresented and have a dispute will also find this helpful. And the date of publication of the hardback edition is the 29th of May 2019. There's the book again, and then there's nothing, as I say, on the back, just the spine there. Just opening it in the middle, you can see this is about estate management. There's a lot of detail here, more than you would think. And I do think estate managers would find this helpful. It looks very much at the law. This is actually estate management itself in this chapter. Let me go to the back. There's actually quite a useful point about drafting as well, because that is important. Reform is at the back, and then after that we get to towards a solution, which I mentioned. This is actually the final chapter, towards the solution there. You've then got the rule and its reasons. You've then got a conclusion, which is not a particularly long one. I'm not going to spoil it. You can read it yourself. Get the book and read it yourself. Then you've got some preliminary points about precedents, and then they're all set out with the numbers P1, P2 and so forth. And it should give you some help depending on what your problem is. Anyway, just a very big thank you to Wildy and to Christopher Jessel. Very grateful to have this book. I think it's helpful to a whole range of people, from the student doing land law through to the practitioner and through to the unrepresented party or the estate manager, or people involved and having a problem or having to face what is required when what we've got here, a positive covenant, is actually raised. Thank you to everybody concerned, and very interesting book. Bye-bye.